she showed up and took her daughter for one night in the last however 3 months. And I'm guessing probably just because it was the day before she went to court.
Mr. Jones, you filed an objection to the child support recommendation. Is that correct?
Yes, Your Honor.
All right. And what is it that you are objecting to?
Well, Miss Jones was supposed to see her daughter 24 days a month or a year, and the child support was calculated based on that. As I said previously, she maybe sees her daughter 10 overnights a year. We kind of went with a higher amount than that. She hasn't had her daughter from an overnight since April of whenever the last court hearing was, except for last night. She showed up and took her daughter for one night in the last however 3 months. And I'm guessing probably just because it was the day before she went to court. So 24 overnights a year is a gross exaggeration on the amount of time that she will see her daughter. And I also just wanted to point out some of the other things in my lengthy response to Mrs. Jones's thing that she wrote. And that's it.
All right. Ms. Jones's camera is now on. Ms. Jones, can you hear me?
Yes, Your Honor.
All right, ma'am. You also filed an objection. What is the basis of your objection?
I just would like it recalculated based on our tax returns. He said he returned in for 2 pay stubs when I think they requested 4. My concern is he has a master's degree. He has a license to practice occupational therapy. He's choosing not to. As far as I know, he hasn't even applied to work in occupational therapy. In addition to that, when we had our calculations done in 2020, he was working part-time OT. And then after that, he started working as a bartender and server.
Guys, this hearing opened with an explosive disagreement over child support, but the real controversy centered on parenting time. The father immediately challenged the recommendation, arguing that it relied on a custody schedule that simply did not reflect reality. According to him, the mother was expected to have their daughter for roughly 24 overnight visits each year, yet he claimed she had managed only about 10. He pointed out that her most recent overnight visit happened just before court, suggesting it was time to strengthen her position rather than demonstrate consistent
as a
involvement.
bartender and server, which he continues to do now and had been for years. So I just like it recalculated based on all of that information.
Part of the court, what was the documents used to calculate the income?
For Timothy,
Yes.
we used his year-to-date for 16 weeks at his current job, and it was calculated and put in at $975 times 52 weeks.
And Mr. Jones, what would you like to say regarding your income?
My income is what it is, Your Honor. I am bartending and waiting tables because I have to, because we live in northern Michigan where there are very few jobs available. The one I had was one of the only available within an hour away from my home. I've driven an hour away from my home here before. It was miserable. It was one of the things that cost me my marriage. I was bartending and waiting tables to be able to pay child support because for years I paid while having the children full time. Miss Jones filed a false police report and got me fired from my job because the police showed up and went through their cameras after she said I broke into her home. And then after the weekend, all of a sudden she drops the charges and says she can't find the video of me breaking into her home, which is just preposterous in every possible way. And so my job fired me because they didn't want the police showing up, checking out their therapist for home invasion, which I guess it's not even my employer that fired me. It's the facility that we work at that we're contracted with demanded that I be fired because they didn't want the police in the facility anymore. So yes, I'm bartending and waiting tables with a master's degree. I'm making good money. I mean, $1,000 a week is about what I was making when I was practicing. I continue to look for a job. I have applied for several, but like I said, I'm not going to drive.
As the discussion shifted, the mother challenged the financial calculations instead. She argued that the father's earnings should be based on his qualifications as a licensed occupational therapist rather than his current work as a bartender and server. In response, the father explained that employment opportunities near his home were extremely limited. He stated that he had previously commuted long distances, damaging both his finances and marriage, and insisted he was earning a comparable income despite changing careers. He also accused the mother of filing a false police report that ultimately cost him his
Not going to
therapy
drive
position.
over an hour away anymore, especially when I'm making about the same amount of money as I was making before. And Miss Jones says that you guys didn't have her correct income information. Well, she was given the same 14 days to give the information that I did. I gave them my previous year's tax returns and my last two pay stubs, exactly what they asked for. I've been at this job for almost a year now. I don't know, 10 months now, 8 months, something like that. It's where I'm going to be for a while until I find something very close, and I don't see that happening in the near future. But even if I do, the income's going to be about the same, like I said.
All right, thank you, sir. Ms. Jones, anything else that you want to say regarding your objection?
Yes, and he made that much money waiting tables and bartending in addition to his occupational therapy job. There are jobs listed on Indeed for months in Boyne, Gaylord, Grayling, Petoskey. He says he hasn't applied. I doubt he's applied because last time he said he didn't want to even do that job anymore, that he wasn't happy. He has the means to make that income to get a job. He's not currently doing it. There's no reason that I know of that he can't be hired in as that. There was an incident where someone broke into my home when my kids and I were downstate for Thanksgiving.
It's not
And
true.
excuse me,
Well,
I talk.
I don't know whether or not there was a break-in or not. It's certainly not going to be determinative of what is the decision I have to make, so it's not really relevant.
Well, I just wanted
So anything else you want to say?
he had it on record, so I thought I could have an opportunity to explain my side as well.
Well, I'm not using what he said as any sort of evidence in this matter.
Thank you.
All right, anything else you want to say, ma'am?
I was out of town for a little bit. When I came back to get my paperwork done, it was a few days late. I thought it was 14 days from me receiving it. I did turn in my paperwork in person, and they said everything looked
The courtroom quickly became a battle of conflicting narratives. The father maintained that he had submitted every financial document requested, including tax returns and recent pay stubs, arguing that his current earnings accurately reflected his situation. Meanwhile, the mother insisted he had intentionally avoided higher-paying occupational therapy positions despite available job listings. She denied his allegations regarding the police incident and requested that both parties' incomes be recalculated using updated tax information. Throughout the exchange, the court repeatedly redirected both sides, emphasizing that unsupported accusations would not determine the outcome.
They said everything looked like it was proper, what they needed. I'm just asking for it to be recalculated based on that.
You're asking that your income be recalculated?
Both of ours with the tax income from last year.
All right, so is there a difference between the amount that was calculated for you and what you are saying you're actually earning?
No, I did have a raise, and I just want to make sure that they had my correct. I did have a raise recently, and I want to make sure they had that information.
All right, in front of the court from Ms. Jones's employment, how was that calculated?
The annual amount was calculated from what the employer disclosed. The amount was $73,908.25. Her information that she submitted was within $300 of that amount.
Okay. All right. Thank you. All right. Well, having heard from both parties, I am going to deny both objections. I understand Mr. Jones is concerned with the overnights, but we need kind of a record. Mr. Jones, if you keep track of how many overnights actually happened this year, and we're not near that 24, then you're certainly free to file a new motion to change the overnights, but I'd like to have a track record of some time since this recommendation goes into place as to figure the overnights. You're not going to have a major change probably in support because it's already at a pretty low number of overnights anyways, but I think we need a track record of what's going on with the amount of overnights that are actually happening. For today's purposes, I'm going to deny that your objection as well as Ms. Jones' objection. Both have the right to file an objection to my decision within 21 days and have the matter heard before the judge. That information will be provided in the paperwork that you received from the court regarding today's decision. All right, thank you both for appearing. You are all set and can sign off. And what are you looking to change?
Just what has happened for the last 5 years. The kids haven't been going to their moms at all. I've been paying child support the entire time.
Here's where everything took a decisive turn. After reviewing the evidence and listening to both arguments, the court rejected every objection presented that day. The judge acknowledged the father's concerns about the number of overnight visits, but explained that a documented record would be necessary before modifying the parenting schedule. He encouraged the father to carefully track future overnight visits and return with evidence if the situation continued. Both parents were informed they could challenge the ruling within 21 days, bringing the hearing to a firm but unresolved conclusion.